You struck the officer in the right side of his face with your hands. You punched him. It's in the debate. I'm speaking. Don't be rude. Are you interrupting this court? No, you interrupt. I get to speak, then you can speak. We learned this in first grade. That's rude. Shinton Edmonds.
You see him at the court to tell him at best what he's been charged.
Edmondson, please.
I think we're still working on that one, Judge.
Thank you. Clinton Edmonds.
You watched the video on this one? The media.
Yes.
All right. We now call cause number 26 CR 909, the state of Texas versus Clinton Thomas Edmondson. That's you, sir? Are you Mr. Edmondson? You have to speak up so she can hear. She's the court reporter. Good. Thank you. I'm sorry.
My mother's name got covered over for old age. I was in jail before. They gave me a name like this for the hospital.
But you are.
The courtroom became tense as the judge addressed Clinton Thomas Edmondson, who is facing a second-degree felony charge of assaulting a peace officer. According to the indictment presented in court, the incident allegedly occurred on or about March 5, 2026, in Jefferson County, Texas, after police responded to a report involving a man wearing a white hat and tan pants who was allegedly breaking the window of a pickup truck and threatening another person with a metal fence post. When officers arrived at the scene, they allegedly saw Edmondson walking away and instructed him to stop. The court heard that Edmondson was carrying a fence post, which he eventually dropped before stopping. As officers attempted to conduct a pat-down for weapons and ensure everyone's safety, the allegation states that Edmondson struck one of the officers on the right side of the face with his hands, resulting in an alleged physical struggle. The situation reportedly escalated until the officer activated a taser and Edmondson was
Responded to the report of a person with a white hat and tan pants, and that was described as you, breaking the window of a pickup truck while trying to assault the person with a metal pole. This happened on Magnolia Avenue. The police arrived, saw you, and called for you to stop as you were walking away. You were holding a fence post and you dropped the post and stopped. When the police began to pat you down for weapons and safety, you struck the officer in the right side of his face with your hands. You punched him. It's in the debate. I'm speaking. Don't be rude. You get a chance to speak, but don't.
Eventually subdued and handcuffed. The property owner allegedly told police that Edmondson had been asked to leave because he was trespassing and had become angry before threatening him with the fence post. During the hearing, the judge carefully explained the allegations and reminded Edmondson that he was facing a serious felony charge with a potential punishment range of 2 to 20 years in prison and a possible fine of up to $10,000. However, Edmondson appeared confused and repeatedly attempted to explain his side of the situation, mentioning previous experiences and saying that he did not want to say the wrong thing. The judge repeatedly told him that he would have an opportunity to speak, but needed to allow the court to finish speaking first. As the discussion continued, it became clear that Edmondson was struggling to understand or engage with the allegations being presented. Rather than attempting to resolve the matter immediately, The court decided that the case would proceed toward trial so that a jury could ultimately determine.
Oh, do you understand what you're charged with and the punishment range applicable here?
Do you understand what you're charged with?
You understand what you're charged with and what the punishment range is, up to 20 years in prison if convicted.
That's your question?
No, you're going to get a chance to speak in a minute. Just do you understand what you're charged with? But I just read to you in English and the punishment range of up to 20 years.
I don't know. I don't mean no harm, but I don't want to say the wrong thing because I know who I am. I know who I am. I got shot on the front premises. I got shot on the front premises way before.
We just need to know whether or not you understand.
Nobody else, I don't know.
There's nothing about
I don't have
a
no
shooting.
friends walking the street. Someone was talking to me, and I don't know their conversation.
Okay.
But when
All right. So what we're going to do then,
I don't know who's
Determine the facts and decide his fate. The courtroom then moved on to another serious case involving Dantrell Tyrese Jones, who was charged with the second-degree felony of burglary of a habitation. According to the indictment, the alleged offense occurred on or about March 11, 2026, in Jefferson County, Texas. The judge explained that the charge itself could carry a sentence of up to 20 years, but Jones's previous criminal history could dramatically increase the potential punishment. The indictment allegedly referenced previous aggravated robbery convictions from 2018, as well as another robbery conviction in 2025. Because of those prior convictions, the court explained that if the allegations were proven and the applicable enhancement paragraphs were established, Jones could potentially be classified as an habitual offender, exposing him to a punishment range of 25 years to life in prison. The judge made it clear that probation would not be available under that enhanced punishment range.
Anything else?
next is Lucy Johnson. Thank you. Mr. Laird's case. Dontrell Jones. Here, Dontrell Jones, is that you, sir?
No.
That's you? Welcome. And this is cause number 26CR768, the state of Texas versus Dontrell Tyrese Jones. And here is Mr. West, your attorney, and the prosecution is Mr. Laird. You were charged in this case, sir, with the second-degree felony of burglary of a habitation. And this indictment states this occurred on or about March 11th of 2026 in Jefferson County, Texas. And that's serious because that would carry with it up to 20 years in prison. But your criminal history has caught up with you.
And emphasized how serious the situation had become. Jones's attorney then raised concerns about his client's condition and communication, explaining that he had attempted to speak with Jones at the jail, but that Jones had refused to meet with him. The attorney also explained that Jones appeared to believe he was in custody for theft rather than burglary, creating concerns about whether he fully understood the case against him. The judge pointed out that the indictment clearly charged burglary and reminded Jones that the grand jury had returned that indictment. The court emphasized that the allegations were still matters for the legal process and that it would ultimately be up to a jury to determine whether the prosecution could prove the case. The discussion also highlighted the importance of communication between Jones and his defense attorney, with the judge encouraging them to speak privately and work through the discovery and potential legal strategy. The judge acknowledged that the possibility of 25 years to life was extremely serious and encouraged everyone in
Robbery conviction on that same date in the same court. So on September 17th, 2018, you were convicted twice of aggravated robberies. After those convictions became final, paragraph 4 of the indictment goes on to state that you thereafter committed the felony of a robbery, a second-degree felony, and you were convicted of that. I think I remember, because I remember faces, you were convicted of that in this court in September of 2025 last year. So if paragraph 1, if you were convicted of this new burglary of a habitation and paragraphs 1 or 2, and paragraphs 2 or 3 one or more of the aggravated robberies were proven true. And then this other
involved to carefully consider the situation. The courtroom atmosphere remained tense as the judge attempted to keep the proceedings organized while also making sure the defendants understood the seriousness of the charges, the potential consequences, and their right to have their cases properly addressed through the legal system. These proceedings demonstrate how quickly a courtroom can become complicated when defendants struggle to communicate with the court or their attorneys, particularly when serious felony allegations and significant prison sentences are involved. In Edmondson's case, the next major step is a trial where the evidence, witness testimony, police accounts, and defense arguments can be presented before a jury. In Jones's case, the focus is on his attorney's ability to review the evidence, communicate with his client, and determine whether the case can be resolved through negotiations or must proceed toward trial. Both cases carry potentially life-changing consequences, and every hearing can become an important...
which is not good. All right, what are we doing? That's
You know, if I get a little time, I'd like to have him evaluated. I have gone to the jail to talk to him. He's refused to come talk to me. This morning, I tried to talk to him again. He indicated that he's here for a theft and not for a burglary, and then walked away. Went back and turned off my cell.
there's the indictment
Right.
says burglary. The indictment says burglary. That's what the grand jury indicted you for right there. Burglary.
I've tried to go over the discovery.
That's the way that's the law.
And
And it's up to the jury to decide if it's true or not.
Get a pre-warrant.
Huh?
We get a pre-warrant.
You got to talk to him with that. He's your lifeline. He's the man who helps you. Y'all have to do that privately. I can't get involved in that. But if it's fair, if something can be worked out, we'll do it. But 25 to life is not good. Y'all talk about it.
I was if he'll talk to me.
Okay.
Yeah, he has,
All right.
Yeah,
Well, you work with him. He sounds like
I'm
an
trying.
intelligent guy. He's concerned about his life. Okay. James J. Nelson, please.
Your Honor, they've made us a new offer this morning.
Great. Oh, I'm sorry.
If we could have 1 week.
Oh, okay. I was excited about it.